So Aaron, thank you for that introduction of the ProPublica article. So I first want to kind of talk about artificial intelligence and its impact in the criminal justice space. I want to really focus on pretrial risk assessments because I think they just kind of show a specific use and instance of how AI can have perverse effects on certain people, certain demographics that we care about. So what is a pretrial risk assessment tool? It essentially is an algorithm that uses historical data from a variety of sources to forecast a defendant's likelihood of failing to appear before the court date or reappearing before the court with a new charge in the interim. And, this standard comes from the Bail Reform Act and its reading of the Constitution where, it outlines kind of a two-pronged test of dangerousness and recidivism. And this seems like, okay, this kind of has some objective turn to it. So let's talk about kind of some of the factors that are considered by the tool. So of the approximately 24 different tools that our research has been able to identify, and they all work differently, they're created and designed by different people working in a variety of jurisdictions. Essentially, you look at something like defendant age, it's just a number. You put the number in, boom. Number two, substance use, it's a yes or no toggle and it's done. But let's move down, for example, to number 10, community ties. So let's take two people, for example. Johnny. Johnny lives in County A. He was apprehended for an alleged crime in County A, but is a member of the YMCA over in County B. He lives on the county line, so it's easier to get to the YMCA in County B than it is to go across town in County A. Is he a flight risk because he's going to leave the county just to go play basketball? What about Jalissa, for example, who she lives in a community where there is no YMCA, right? But she's known to play basketball in a pickup informal basketball league in her city or area. Does she not have community ties? And so you can see how these things kind of have perverse outcomes. Another example just comes from my experience having worked for a summer in Philly Defenders. It has nothing to do with risk assessments, but does show how the pretrial system needs reform globally. So this person was accused of a crime, relatively petty crime, nonviolent crime, and the prosecution gets up and says, this person doesn't have a job, they answered that they were unemployed on the form, they should be held for trial. And the defense counsel gets up and says, actually, my client had a job until you kept him in jail and he missed his shift this morning. So it was in fact this pre-trial hearing that changed his outcome and his ability to go home to his family. So you can see how some of these things have softer implications that it's hard for us to find out how one tool is quantifying these things, let alone 24 different ones. So here are some of the key problems with risk assessments, and I think they're best summed up in something that Sakira Cook said that I really liked. She said, there are no technological solutions to structural systemic problems, right? You can't just algorithmatize these things away, right? Put them in a machine and the machine is just gonna be objective and give us a fresh take. There are a plethora of racial, gender, socioeconomic, and other biases that are built into the data sets that power these tools, that these tools are making decisions based on historical trends of similar types of people, right? And essentially, if those things are what's going in, it's garbage in and you're gonna get garbage out. And the tools aren't transparent, right? We don't know how one tool weighs different factors. We don't know the changes or updates made to these tools, how they affect someone, right? Someone who maybe went in for arraignment or bail hearing on Monday and it was updated on Tuesday, and a similar defendant comes on Wednesday and it could have a totally different result. We don't know about what that update did to the tool, how frequently it's updated, and if it yields different results. And in general, I think we're thinking that the tool has a tendency to disincentivize judges' accountability. They're hiding behind the tool. Oh, the tool says they're a high risk, so I'm gonna keep them. And you might not know, kind of in the examples I illustrated, that the high risk might be easily mitigatable with some more knowledge or understanding about a job, for instance, that was lost because of the process, or community ties that need to be better explained that aren't captured by an algorithm. So these are the kinds of problems that we wanted to address in our civil rights principles. So the ProPublica article was certainly one of the things that alerted us to a problem, and we did our own research. And in 2017, the Leadership Conference, with a coalition of over 118 different groups, promulgated the civil rights community's principles regarding pretrial risk assessments. And, you know, the Leadership Conference's stance on risk assessments is that we don't want to promote their use, right? However, we understand that they are being used, right? And so we're not going to turn a blind eye simply because we don't like their use at all. We want them, if they are going to be used, if communities are deciding to use these tools, we want them to be fair, right? And used in a way that minimizes inequities and unfairness. And so we want to eliminate racial disparities in outcomes as much as possible. We want community input from and oversight from the beginning to the implementation processes. We want regular and independent validation of these tools to make sure they work in the most fair way. And we believe that framing is important, right? We want tools to never recommend detention. If there's a tendency to recommend that someone should be detained, it shouldn't recommend detaining, it should recommend a robust hearing, right? Where a judge can hear the circumstances and defense counsel and the prosecution can kind of really mount defenses to that person's incarceration to preserve their presumption of innocence. And we should frame these things in the likelihood of success and not failure, simply as a matter of dignity, right? No one is a failure. All human life does matter and has a potential for success. And transparency also seems to be kind of an overriding problem with these tools. We know how they work from the back end, but we don't know how they're working in real time so that someone can mount a credible defense. So some of our vehicles of education and advocacy, so Galen mentioned the Civil Rights Table on privacy and technology. We host about 13 different working groups, one of which is the pretrial decision-making working group that exclusively has worked on these things, even in specific jurisdictions like California, Illinois, Pennsylvania, and other jurisdictions. The Leadership Conference, we have our organic arm of research and education, the Justice Reform Program, and we're also a member of the Justice Roundtable, another table organization where we've talked about some of these machine learning biases and problems in the criminal justice space.
Prince, you ended your slide deck talking about the fact these principles are out there. And there's this dissonance almost of we don't like these tools, we don't want them used, but states are adopting them and they are being used. So talk to me a little bit about what you see in the year ahead for the Franchise Council.
So first, we definitely do see going to specific jurisdictions, really doing case studies to see the different nuances of how tools are being used and really create a catalog of where they're being used. I think there are like 3,148 different county and county equivalent jurisdictions in the United States. And that doesn't count redundant jurisdictions like states. And we don't know in how many of those there are being used. We've identified them because people have come to us, but I think the role of the Leadership Conference is to unite people at the tip of the spear, community organizers specifically, and researchers and lawyers together at the table, right? Our civil rights table or other tables. And our job is to kind of convene these people in one place so there's an output of a community-oriented result that people can be proud of or can definitely own the results of that, but just to have things unwieldy, introduced in their jurisdictions and used against their people and their communities in a way that's opaque and non-transparent is unfair. Could you ask the last part of your question? It trailed off.
Yeah, just if Medicaid or SNAP or TANF or other public benefit programs are ever considered in that list of variables.
I've never seen them used. It's strictly just like the history of the individual person, and it goes along the lines of profiles of kinds of people the system believes tend to be less educated, only have one parent, depending on their age, right? Determines their likelihood of recidivism or a likelihood of committing a dangerous crime. I have not seen a risk assessment tool that considers those things, but right, this is one thing that we can say could be a potential problem, right? An interlinking of social systems and kind of a divulging of personal information, irrelevant information that can prejudice a client, right? Especially if you have a judge that has a prejudice against people who use social services or someone in a certain place. So that's a potential harm that I'd like to write down.
You talked about pretrial specifically, but is there any other way that automated technologies, AI, is impacting the criminal justice system more generally?
Yes. So I actually anticipated this question. 20 more minutes. Thank you, Nicole. In general, I mean, we're seeing an entire ecosystem of technologies that are challenging constitutional rights, civil rights, and human rights. And, you know, we've been trying to map all these technologies because they can become a whack-a-mole. You're focusing on risk assessments, here comes facial recognition, here comes some other thing, and you're just jumping from topic to topic. So I've been trying to think about these things in two parts in a criminal justice context, right? One is the executive law enforcement uses, which principally buck up against Fourth Amendment rights, right? Rights against search and seizure. And the second is judicial uses of AI. And I mean, we talked about risk assessments used in pretrial, but at any juncture of judicial discretion, a tool can be used to legitimize a decision that a judge makes. And the judge says, oh, it just told me you were high risk. Oh, it just told me to surveil you forever. And you're seeing kind of perpetual surveillance, socioeconomic, gender biases that are following people for the rest of their lives. I mean, if you commit a crime, as you saw, I think it was the third factor, if you commit a crime once and every other time you go again and again and again, that factor is always going to be held against you. You're always going to be held till the trial, right? And so we are seeing these things proliferate, and you know what to do about them. We have to catalog instances where they're happening and bring those up and just kind of keep a tally as they go along. So when the moment arises where a legislature is really interested in this, where the Senate and the House are really interested, we can pounce and say, here are 20 instances across the US where they're being used in a bad way, and this, and this, and kind of show the inner workings, the networking of problems with finance, with voter suppression. Like, the more that we can network problems and similar abuses, it lends to our credibility as people who can reasonably advocate against the proliferation of these technologies.